Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة. أسعد الله أوقاتكم بالخير. أهلا بكم مستمعينا في سينا 102.3 FM وحلقة جديدة من برنامج يور رايتس. حلقة اليوم مخصصة لقضايا حوادث السيارات. بإمكانكم المشاركة في هذا الموضوع على الأرقام 313-769-6666 519-256-1023. مكتب المحامية جومانا كيروز يستقبل قضاياكم المتعلقة بالبيرسونال انجري ومن ضمنها قضايا حوادث السيارات، قضايا الهجرة والتجنس، قضايا الإفلاس، كريمينال لو، فاميلي لو، والضمان الاجتماعي وإصابات العمل. الاستشارات مجانية 248-557-3645. حلقات برنامج يور رايتس يعاد بثها مرة أخرى على الموقع الإلكتروني yourrights.com/radio أو على اليوتيوب. كل ما عليكم والبحث عن قناة جومانا كيروز. أهلا وسهلا فيكم جومانا، تحياتنا لك.
صباح الخير
صباح
رامي.
النور.
صباح الخير لكل المستمعين.
أهلا بيكي.
نحن اليوم رح نحكي عن قانون حوادث السيارات. أي شخص بحب يتواصل معنا على 313-769-6666 و 519-256-1023. نستقبل اتصالات، تعليقات، إن كان سؤال حادث سيارة، إن كان سؤال عن القانون الجديد عن حوادث السيارات اللي جزء منه بلش ب 11 حزيران 2019، اللي جزء منه بده يبلش ب1 آب 2020، والجزء الآخر اللي بده يبلش ب1 آب 2021. المحامي جون شرودر رح يوصلنا عبر الهاتف ومفروض يتصل قريبا على الهاتف لحتى نتكلم عن موضوع حوادث السيارات. بحب ذكر انه نحن صرنا على الهوا رامي كل يوم كل يوم باختصاص معين من الاثنين للجمعة. ابتداء من الاثنين القادم بإذن الله رح يكون الوقت ثابت الساعة 1 بعد الظهر، 2 3 4 خميس، وإنما الجمعة بنخليه الساعة 3 بعد الظهر. التنين ما بقى في الساعة 2 رح يصير الساعة 1 ليلي بيتسمعوا بيحبوا يتصلوا يسألوا أسئلة عن الإيميغريشن لو يتصلوا بين 1 و2، مش بين 2 و3. 3 هو موضوع البانكرابسي، الأربعاء هو موضوع الإصابات الشخصية. يعني اليوم كان مفروض يكون امبارح كان لازم يكون اليوم، بس المحامي مايكل رات ما كان بيقدر، عندهم ترايل ببلش اليوم. نهار الخميس ضمان الاجتماعي الإصابات ضمن العمل، نهار الجمعة كريمينال وفاميلي.
بالفعل.
هذه أول نقطة.
جمانة، الملفت امبارح كان عندنا متصل سأل سؤال متعلق بحوادث السيارات أو بالأحرى بالتأمين، أنه كان يحكي أنه أسعار التأمين صعدت عليه هذه الفترة اللي
بيقول
لازم
من
يدفع
$1000 ل 1800
ل 1800 بالوقت اللي كثير من الناس توقعوا.
مصطفى
يعني كان يعني وفي بعد التصور موجود أنه بما أنه صارت القانون يعني وافقوا على القانون خلص الأسعار رح تنزل وبشكل سريع وكل شيء رح يكون تمام. في نظرة خاطئة بالموضوع، يعني
نظرة خاطئة. أول شيء بالنسبة للأستاذ مصطفى، أنا بعد ما عندي تفسير، بعد ما بعرف إذا اتصل بالمكتب، ما بفتكر لأن بعد ما وصل لي المسج. بالنسبة له بعد ما عندي تفسير منطقيا باللي عم بيقوله، لأنه كيف انشورنس بوليسي بتنط من $1000 ل $1800؟ يعني أنا ما سامعة فيها هي. ابتداء من 11 حزيران الكريدت سكور تبع الانسان، لانه كنا قبل نطلع على الكريدت سكور للاسف كان عامل من العوامل اللي الانشورنس كومباني كانت تاخذها لتحدد درجه الريسك اللي هذا الانسان بيشكل. بس ابتداء من 11 حزيران الكريدت سكور ما عاد يقدر يستعمل. لنقول سلم جدلا صار عنده مخالفة سيرية، صار عنده حادث سيارة، ما بتنط من $1000 ل $1800. I really don't understand. يعني ما عندي تفسير منطقي للنط بالانشورنس، بس بكل الأحوال هو منه ملتزم بالانشورنس تبعه. he can shop for other insurance codes. هلأ لنجاوبك على سؤالك إنه العالم بتفكر إنه تغير القانون. أول شيء القانون تغير على تصعيديا على 3 مرحلة. أول مرحلة بلشنا فيها، المرحلة اللي بلشنا فيها ما رح تأثر ماديا على الأشخاص. يعني يس الكريدت سكور ما بقى يستعملوا، بس انتبه اللي عنده كان بوليس التأمين يخلص البوليس التأمين ليجدد البوليس التأمين ليقدر يستفيد. صح. إنه الكريدت سكور ما بقى يستعمل. التغييرات اللي صارت ب 11 حزيران 2019 ما بتأثر بعد على توفير. هل هو المحامي معنا؟ إذا بتسمح لي كمل الجملة ومنطلب منه يكون على الهاتف. التغييرات اللي صارت ابتداء من 11 حزيران أغلبيتها ما عدا الكريدت سكور ما إلها تأثير على التوفير. حتى لو في اشياء صارت effective ب 11 حزيران مثل اللي حكينا عنه المانج كير اوبشن، بعد لهلا ما شفنا بوليس التأمين فيها مانج كير اوبشن، لأنه صحيح القانون قال ابتداء من 11 حزيران صار فيها الانشورنس كومباني تقدم هاي الاوبشن اللي بتأهل الإنسان يشتري بوليس التأمين أرخص. ما الانشورنس كومباني بدها تكتب العقود وبدها ترجع تبعت العقود للديبارتمنت اوف انشورنس اند فاينانشال سيرفيسز بولاية ميشيغان ليعطوا اوكي على العقد ليرجعوا يبلشوا يقدموه يعرضوه. يعني في القانون قال ابتداء من 11 حزيران، بس في هيدا القانون، بس في التطبيق بين ما طلع القانون وبين وقت التطبيق في شهور وشهور وشهور. مش كوني فكانة. صحيح انه القانون بلش يتغير ب 11 حزيران. التغيير اللي رح يبين هو ابتداء ومن بعد 1 جولاي 2020. وخلينا نسأل ذات السؤال للمحامي جون شرودر اللي هو محامي من المحامين عندي بالمكتب اللي بيجتمع مع كل موكل بحوادث السيارات واللي هو بنص المعركة، واللي هو أكتر مني بكتير بنص المعركة لأنه بيستقبل كل إنسان كل حادث سيارة. جون.
Yes, Joumana, I can hear you. Can you hear me?
Very good. Good afternoon. How are you, Attorney John Schroeder?
Good afternoon. I'm doing very well. Thank you so much for having me.
My pleasure. And thank you for being able to call us here at the radio. We're talking today about car accidents and we welcome people's calls. In a little bit, Rami began by asking a question. He said, and I answered it, but I'd like your take on it. Sure. Rami said, a lot of people think that because the law has changed and that the governor on June 11, 2019, passed a law into action, that people should start enjoying relatively quickly, as in now, a month or two later, cheaper premiums. Are people wrong to assume that?
Well, yes. Unfortunately, that's probably not the case. The insurance companies will first have to redo all of their policies. And quite frankly, a lot of the rate reductions, really, they don't come into effect until 2020.
Right. July 1, 2020 is when your zip code will not matter anymore. July 2021 is when the doctor's payments will dramatically go down, correct?
Yes, that's
the only thing that's been in effect that is of any significance right now is the credit score.
Yes, that's correct. There is a provision under MCL 521.53 and 62, which indicates that the insurers are no longer able to use things. They're no longer able to discriminate, basically, on various issues. They're no longer allowed to prohibit insurance coverage based upon the establishment of credit score or credit rating classification.
Okay, so credit score, Rami, is out the door beginning June 11.
That's correct.
Yes.
Yes, and there also is a provision that's preventing them from denying coverage or using income, gender, address, zip code, ethnic group, religion, marital status, or nationality as well in calculating an insurance score.
Effective when?
Well, that's effective immediately as well.
Okay, so do me a favor, repeat those, because those mattered before. Gender.
Yes. So income, gender, address, zip code, ethnic group, religion.
Hold on,
status.
zip code?
Mm-hmm. Mm-hmm.
The zip code is not in effect until, it continues to be in effect until June 1, 2020.
Well, so again, that's when the new insurance policies will be written. And so it's at that point, because this is what they're prohibited from doing in calculating an insurance score. So when they recalculate all these insurance policies, none of these things are going to be allowed to be used.
Okay, but but John, this is confusing. There are some parts of the law that became effective on June 11, 2019.
Yeah,
and some parts of the law will become effective July 1, 20.
Yeah,
Let's clarify, between June 11, 2019 and July 1, 2020, somebody's zip code is still going to matter.
That's correct. That's
okay.
Correct. It still matter today.
Today, until July 1.
Right.
2020.
Right.
Another 11 months.
That's correct.
What about gender?
So I believe all of those things that we just listed, all of those things are going to be in this, not allowed.
Effective July 1, 2020.
Correct.
So
Correct.
to make it simple for listeners, the only thing right now that is on the side of everyone whose credit score is low is that effective June 11, if you buy new insurance on June 12 or today on August 1,
Correct.
your credit score is not an issue. Nobody will look at your credit score, correct?
That's what the statute says. It says effective June 11, 2019, an insurer shall not use an individual's credit score to establish or maintain rates or rating classifications for automobile insurance.
Okay, so going back to Rami's question, why is it that some people think, because this was so sensationalized in the media, why do some people think that they should enjoy right now premium reductions and they're not seeing it?
Well, I can't speak to why they necessarily believe that, except that the fact that the politicians billed it as a great way to reduce insurance rates.
Right. And so people thought it's going to happen right away.
But what they didn't tell you was that it's going to take some time. If we even see them, because I actually and I apologize, I don't mean to interrupt, but I would even argue that it's not necessarily guaranteed that we will see those rate reductions, because they only guaranteed the reductions for the personal injury protection portion of your bill, and because bodily injury limits are mandated to go up, we also will see I can almost guarantee there's going to be an increase in the cost of coverage for that portion.
Right.
So,
Rami, we did talk about that. We talked about how, in theory, they say that your premium for the medical and all of that will go down, but that does not mean that your part of the premium for the pain and suffering will not go up. So that's why I always said to you when we talked about this before, let's see.
Right.
This is what the law promises, but a lot of lawyers and experts are saying, we're not so sure. Let's see how this unfolds.
If I may, there's another reason why many people are expecting, including myself, are expecting to see the bodily injury rates go up, and that's because bodily injury prior to the June 11th date, you could not claim any medical bills as part of personal injury protection. You had to go through your own insurance or the Michigan Assigned Claims or whoever was the highest order priority insurer for all your medical bills. But as these new policies come into effect with these higher limits of bodily injury going forward, you can potentially claim excess medical expenses from the bodily injury if the other driver that hit you has a good policy.
By the way, the minimum of pain and suffering used to be $20,000, $40,000.
Yeah.
What is it now, effective June 11?
Yes. So the new limits were $20,000 for an individual, $40,000 for an entire accident, and the new limits are going to be $50,000 worth of
100,000, yes.
and $100,000 for an accident. Meaning, if there's more than one person involved in the accident, so let's say there's 3 people, they would have to split up the $100,000.
Correct. So that's a new law. So Rami, like we said in the past, people used to sometimes buy the cheapest policy for protecting people if they cause an accident, and all they had to buy is the minimum, which is $20,000. Now, the minimum, effective June 11, is $50,000. So the value of people's pain and suffering, you can say in theory, is now higher because the law says you cannot buy anything to protect others from you less than $50,000. It used to be 20. Your injury can be $100,000, and if the person who hit you has only 20 is all you get.
Right.
Now the law says your injury is 100,000, and the person who hit you, they have the minimum. The minimum is 50,000.
Yeah, and that's really, I believe as well, that requires a certain waiver of coverage.
That's the thing, yeah, unless you sign a waiver.
Yeah, well, the waiver gets you to the 5,000, I believe. Whereas when you typically the minimum is actually going to be 250,000 in many cases. So it depends. It depends on. Look, there's a lot that we don't know fully exactly on the way these are going to be structured because the insurance policies haven't really been written yet.
But wait a minute. Why is it that you are an experienced lawyer, very intelligent, extremely intellectual? Why is it that I sat in a room with 400 other lawyers with thousands of years of combined experience, and everybody is saying we don't know what the heck the law is? Why is that? Why don't you tell the listeners a little bit?
That's a really good question, and there's actually a good answer to that. So even with all of these lawyers with thousands of combined years of experience, the reality is the law has just changed, and there's no case law interpreting the new law.
But what's wrong? What's wrong with the law as it was written and signed by the governor?
Well,
there is a lot wrong with it.
There's a lot of it that isn't clear. There's a lot that's ambiguous. There's a lot that's still open to interpretation. Just as a very simple example, for one change that we're working with right now in the office here is that there's something called an independent medical evaluation that people are required to go to under the old No-Fault Act, and they're still required to go to, which is where an insurance company doctor gets to evaluate you to see if they think you're injured. But what's changed is that they now have to meet certain criteria. But what's not defined in the Act, even now...
Act meaning the law that the governor has signed,
yes.
Yes.
What is not defined in the No-Fault law is what constitutes sufficient proof or evidence that they meet that. Is a simple letter saying, yeah, I meet the requirements, is that enough? Do they need an affidavit? Do they need actual documents to show that? We don't know.
We don't know until somebody files a motion in front of a judge and enough judges speak on the issue. Are you telling me that this law was not well thought out? This law was not studied carefully?
Somebody thought it out and decided that this would be beneficial for some parties that they represented. I do not believe that overall the law will be beneficial to injured parties. So,
what about the legislature who signed this? When a bill goes into law, this is a law signed by the legislature, the state reps and the state senators and the governor. When you're trying to interpret a law, you look at legislative intent.
Yes.
Meaning,
Absolutely.
What did the state senators think, and what was in the mind of the state reps when they signed this part of this law?
Well, that's a great question. I am not in the mind of any of the legislatures, and I am not one of them. So I cannot honestly speak to exactly what their intent is. But if we look at the press releases that were issued around the time of this act, it all came together very quickly. Most of it was done within really a week or 2 weeks. All together, and the debate was not so much around specifics and legal language. The debate was around how much and whether or not it would actually reduce insurance rates. So the legislative intent, so far as we can tell, was to reduce insurance rates.
But that doesn't help us when we are looking at different changes in the law. What did they mean? Why did they write this word? Okay.
And that's the problem, because all we really know is that they wanted to reduce rates for the average person. And that's a laudable goal. Please
That's
don't
a
get me
good
wrong.
thing, yes, if we can make
that's
it
a
happen.
very-
But
yeah,
they
it's a
left
very
us.
important goal.
But they left us with poor wording, not thought out words, sometimes
Yeah,
inconsistent parts of that law, and we have to figure that out.
And we have to figure that out. And that's part of the trick is it's very hard in just reading the statutes to determine what it actually means. And to be fair, the old law wasn't necessarily clear either. We had decades.
But
and
it
decades.
wasn't that bad, though. It wasn't
Right.
anywhere
We had-
near that bad.
Sure. And we've had decades of litigation to sort out what it all means. But, there are sometimes very, very specific issues that are being litigated. And here, there are some very broad areas where, we just don't know. We just don't know.
Are you impressed by the language of this law?
I mean, personally, I am not. I think that it could definitely have been written in a much clearer way on numerous points. I think that if they decided to debate the law and have a kind of a longer term discussion, as opposed to what appears to me personally as being a little bit of a rushed process,
Right.
I think they could have come up with a much clearer bill.
As a lawyer who does personal injury, particularly car accidents, do you think that it is easy to learn that area of the law in a day or in a week?
I've been doing it for 8 years, and I still don't know all the law.
Okay. So if you were a
No.
state rep, or if you were a state senator, and you want to do a conscious job, how will you even understand what you're about to sign?
Well, Joumana, that's been the problem with politics in general for forever. I'm not even sure that many of our legislators read the bill at all, let alone understood it. The reality is, somebody told them that this would lower rates. And
Somebody
based
told them
on
this
those
would lower rates, and they made a political decision. Those Democrats, they sided with the governor, and the Republicans because, they want to go to their constituents and say, look what I pushed. I'm lowering rates for you.
Yeah. And again, from a political perspective, I mean, if you look at this from a political perspective, you get to say that you were part of a group of legislators who tackled a big problem in Michigan. Insurance rates are too high. I don't think there's really very many people. If we did a poll today of 10 people, I'll bet you 10 out of 10 would say my insurance rates are too high.
Sure. You and I too.
Yeah.
Of course.
And so I don't think that was the problem. The problem is that there are a lot of issues that will not be resolved for many years because of the ambiguities and the potential difficulties in implementing this act. So, but we'll see. So there's just no way that the legislators could have known in a week or 2 weeks what they were really signing into law.
I mean, I'll tell you that if I were a state rep or a state senator and I want to, vote my conscience, I would need to meet with a plaintiff's attorney or plaintiff's attorneys, and I would need to meet with defense attorneys and hear what both have to say, and then do the best I can to understand and go back with follow-up questions and then decide to vote. That's...
Well, but Joumana, that's great, but you're a lawyer. Not all of our legislators, all of our legislators are lawyers.
But let me tell you, if I am a state senator or a state rep, to whom much is given, much is expected. I am voting on something that can make a difference in the lives of others, and it's an important one. Forget, for example, the savings. What about people who now will need treatment, who will no longer be able to afford much medical treatment because it's capped at $250 with the Michigan assigned facilities? I mean, there will be some real life casualties of this law. And
I agree.
I don't need to be a lawyer to do my job. If I am signing a law that has to do with people's lives, that has to do with people's well-being, that has to do with people's health, I have to do the best I can. I have to consciously, study the information and do the best I can to vote for or against. I can't just rubber stamp.
Yeah, and my point was, even when you meet with a plaintiff's or defense attorney, especially if these legislators are not attorneys themselves, that may not even be sufficient just doing
Well,
that.
but
They
don't
may have
sign
to-
up to be, though. Don't sign up to be, a servant of the people. Whether you are a governor or a president or a minister, or a prime minister or a congressman or a senator or a state rep, or you are servants of the people and you're asked to vote. So you have to do your homework, lawyer or not lawyer.
I agree. Absolutely. Absolutely. And that was my point, is that they need to do even more homework if they're not.
But we get the impression from everybody we've talked about, and because of how vague and ambiguous and just confusing this whole thing is. I mean, even the English is not proper English, that it was really hastily written and nobody, it's almost like a first draft.
Yeah, well, the first draft got passed in this case, so this is what we're living with now.
Right. You know, John, we talked about how the governor ran on a promise, among others, of reducing insurance rates, because it is a real problem. Yes, it is.
Yes.
But also wanted to fix the roads, and you had an opinion about that. That, you know, if she should have passed those two bills together, because now she has no guarantee that she'll be able to get the Republicans, you know, to sit on the table and help her come to a resolution about how to fix the roads.
Yeah. Well, that's an interesting point, and I have heard that argued. You know, I'm not a political expert or analyst, but there was a lot of discussion around the time of the passage of this bill about the governor asking for a 50-cent tax on gas. And at least there was some arguments that said, well, if she passes this act and gets everybody on board here, that'll create this political goodwill that will allow her to get her gas tax passed, which according to her was intended to fix the roads. Of course, even the very day of the signing, I was listening to NPR. And they did an interview with one of several members of the Republican Party, and they said, "No, this doesn't change anything. Any bill to raise our gas prices by 50 cents is dead on arrival, and we're not even going to consider it." So I think that argument was certainly made. I did hear that in the news media. I don't know whether or not the governor honestly believed that was going to result from it, but it seems pretty clear that there's not going. It doesn't appear that there was, at least at the time, sufficient support for that measure, and I've not heard anything since that indicates there is now either.
Right. Some of the changes in the law that started effective June 11, 2019 include the possibility of an insurance company offering what's called a managed care option. And before you tell us what a managed care option is and why it's a bad idea for anyone to save money by going into a managed care option, let me just tell the listeners that although some parts of the law started on June 11, like you had said, Attorney John Schroeder, insurance companies now, practically speaking, although they could do this as early as June 11, have to go back, sit down, rewrite their policies to include... I'm sorry?
Recalculate the premium.
Right, rewrite their policies, recalculate the premiums, and then before, insurance companies, we always say that it's a private contract between a person and insurance company, but they are overseen. There is an oversight over them by the state of Michigan, and very specifically by the Department of Insurance and Financial Services, the DIFS.
Yeah.
So they need the time, practically speaking, to write their policies, recalculate their premiums, then submit it to the DIFS, then get the okay to the DIFS before they start offering this to people. So although the law says effective June 11, an insurance company may offer a managed care option, It might not be until January 1, 2020 before it's on the market, so to speak.
Yeah, that's exactly right. I haven't seen any so far that have come up in our practice. It's only been a couple months. It hasn't even been a couple months. Less than
6 weeks.
So, yeah.
6 weeks.
So no, we haven't seen any policies yet. But the managed care option, if you want me to go into what it is, I'd be happy to.
Before you tell us this, tell us, would you get a managed care option?
Well, in order to tell you whether or not I'd get a managed care option,
I'd need to know more. Well, you're not going to know more. You're not going to know more. There is what there is in the law. And today, if you were given that option, would you go for a managed care option?
Absolutely not.
Okay, thank you. So, I always say I wouldn't want unto another what I would not want to be done unto me. I wouldn't want to advise another to buy something that I would not buy.
Right.
And I wanted to hear that from you. So you wouldn't, I wouldn't. Tell us what it is. It promises to get people to buy cheaper premiums, but it's a bad idea from how we understand it. And you can always analyze something from the knowledge and understanding you have. When you know more, you may change your opinion, but it's not looking good at all.
Yeah.
Tell us what a managed care option is.
Sure. So a managed care option is an optional addendum to the no-fault coverage that you'll be allowed to purchase. So we're talking about various no-fault provisions. You can purchase unlimited benefits. You can purchase $250,000 worth of benefits, what have you. What a managed care option is it's essentially an option that you select that requires you to treat in accordance with the insurance company's oversight and within a network of physicians, doctors, treaters that they select.
So let me break that down.
Sure.
We still have the option of unlimited PIP like we have now, but we're going to have to pay a premium for it come July 1, 2020. Or we can buy the $250,000, meaning the most we have for medical treatment is $250,000. Or we can buy the even cheaper, or so they say, a cheaper option. That's like the cheapest premium you can buy as far as the PIP, the medical treatment, called managed care option. So those who are thinking to save money, and money is all they want and they don't care and they don't want to listen to what we're telling them, getting the managed care option from that insurance company, once that insurance company starts offering this, would net them the cheapest premium.
Yeah, so in theory, if you purchased the absolute minimum policy that was available to you and then purchased it, the managed care option, that's exactly right. You would get the lowest possible premium that you could get sold a policy.
So that sounds like a good idea.
Yeah, and you know what? It might be for someone as long as they're not involved in an accident. Because the problem
but the whole idea of buying insurance is risking against an accident.
Is that the point? Yes. So the problem, there's several problems with the managed care option as I see it. And keep in mind, I'm a plaintiff's attorney, so I'm looking at this from the injured party perspective. A defense attorney or an insurance company would probably think that this provision is quite much more rosy than I will portray it as. But what it does is it allows the insurance company to monitor and adjudicate an injured person's care and allows them to use a preferred provider program or other network or other similar option. So what does that all mean? Well, that means insurance companies...
I'm glad you realized that you needed to put this in plain language.
No, so in layman's terms, what this all means is, first, what is their preferred provider program? Well, I have no idea because none of them have been created yet. But you can imagine a situation where they do something similar to like an HMO, okay? Most people are familiar with an HMO where you have a doctor that you have to go to, and then he has to refer you to another doctor, and it has to be within your network. And if it's not within your network, well, you don't really have coverage, or it might be partial coverage, and that's something that insurance companies now get to do. Now,
under the managed care option. So if you're going to buy the cheaper managed care option, you're limited to a group of doctors that the insurance company has pre-selected for you.
Right. Now,
Okay, what's wrong with that?
Well, if they include every single doctor in the state of Michigan, maybe nothing's wrong with it.
Exactly.
But the reality is we don't know what that looks like yet, okay, because they haven't created them, and they haven't gotten that list of doctors. But even no matter what they do, presumably they're going to be selecting doctors
that are favorable to them,
that they're familiar with, and that they believe will end up costing the insurance company less money. Otherwise, why would they set it up? Right? That doesn't make sense.
That's the whole idea, is we charge the person less money if they do the managed care option, because we send them to our own doctors, and those doctors are beholden to us. They're going to be very conservative with the treatment, the number of physical therapy, the number of this, the number of that.
So obviously, I'm sure any of these doctors that will be enrolled in this plan would fervently tell you that they are independent and they can do a good job, and maybe they can. But the insurance company will be selecting them for a reason. And the reason is that an insurance company is in the business of making money, not spending money. So you can guarantee that they've done a cost-benefit analysis, and they've decided that these doctors are more likely to save them money by being in this particular network. And if a doctor is costing them a lot of money, I would venture a guess that they wouldn't be in the managed care option very long. So
correct.
So from my perspective,
so they're a little bit like the IME doctors. There is a reason why an insurance company will send you to this IME doctor, not that doctor, because they already know.
Yeah, that's exactly right. And for the listeners, an IME doctor is an independent medical evaluator, which is a doctor selected by the insurance company to determine whether or not.
But it's not independent. It's not independent. It's a misnomer that person is not an independent medical doctor. They call them independent, but they're very dependent on the insurance company, giving them business, paying them. That is why we often obtain the financials when we depose an IME doctor or we go to trial, the financials of the IME doctor, to see how much money that doctor made from seeing people sent to him or her by the insurance company.
Yeah, well, and in the past, some of these supposedly independent medical evaluators have done nothing but, or almost nothing but, evaluating patients for the purposes of
cutting them off,
potential denials for insurance claims. So,
and here it's going to resemble that, not for denial, but very conservative treatment. Somebody may need 20 physical therapy sessions, but may only get 5 because that doctor, part of that list that the insurance company put, because you bought a cheaper premium, will decide that you only need 5 physical therapy sessions, not 20, when you need 20. And I'm just using an example.
Yeah.
So they will be conservative, because that's one way they save the insurance company money.
Yeah. And another example of that is, a doctor may say, well, you know what, you're in a lot of pain right now. We believe that an injection, maybe a steroidal injection, maybe a platelet-rich plasma injection, there are a lot of different types of procedures that can help either repair or reduce pain for people with various injuries, right, like a rotator cuff tear or otherwise. And one doctor may say, you know what, I see you're in a lot of pain right now. This might resolve with physical therapy alone in 6 or 12 or 18 months or maybe 30 days, I don't know, whatever the case may be. But we believe that right now the best care for you is an injection. But this injection might be very expensive to an insurance company. And I think the concern on the part of specifically plaintiffs' attorneys is that these doctors that are in this managed care option, known to have conservative treatments, would be less likely to recommend these types of treatments that may be more expensive to the insurance company, because they know that an insurance company won't put them on the managed care option plan if they're recommending these expensive treatments.
So they're inherently, so is it fair to say, and let me just remind the listeners that we're talking with Attorney John Schroeder from our auto accident department, and we're spending the whole hour talking about car accidents, about the new law and so forth. So the doctors that are chosen by the insurance company as part of the managed care option are inherently biased. There is a reason why they made it into that list.
Yeah, well, and that's I mean, yeah, I mean that's what I think most plaintiffs' attorneys believe is that they are, and I would have to agree. I don't think that the vast majority.
There will be the one or two doctors, but I don't think they're going to stay on that insurance list for very long.
Yeah, I mean, look. There's always exceptions to every rule, and I am not going to sit here and say every single quote-unquote independent medical evaluator renders a bad opinion and is biased and they're wrong every time. That's simply not true. But there's enough instances that I've seen where a treating doctor who's been seeing this patient for months comes up with a completely different analysis from an independent medical evaluator, that you have to think that there's something going on there. There's a disconnect between what this doctor who's paid by the insurance company is saying and the doctor who's treating the patient. Okay.
Correct. And in fact, a number of us lawyers have likened this managed care option and that list of doctors that the insurance company will be putting together and offering as a way for people who are in car accidents to treat in exchange for selling them a cheaper premium because they entered into the managed care option. We kind of likened it a little bit to a Concentra clinic.
Yeah, I mean, there's a lot of various comparisons you could make. It's certainly possible. I like I said many times, I don't know what the ultimate effect of all this is because we don't even have that list of doctors from any insurance company yet, or at least I don't. I haven't seen a single one yet. I haven't seen a managed care option put together yet. So on some level, we'll have to wait and see. But as far as I'm concerned, to answer your original question, would I be enrolling in something like this tomorrow? I can almost certainly say I would not.
100%. So again, saving money is a very, very good idea, and there's something in the law that's become in effect on June 11, 2019 that is in all likelihood going to save people money, and that's the managed care option. But we are coming out and saying it's a very, very bad idea. So I wouldn't, Attorney John Schroeder, every lawyer I've spoken to, even defense lawyers, they're not going to buy a managed care option. They want the best protection for themselves because they too, right, God forbid, could be the victim of a car accident. Nor should adjusters purchase their own managed care option. Think about it, because again, number one, we don't know how it's going to unfold, so that alone is enough. But as it's written, and just the fact that it's an insurance that's a list put out by the insurance company should cause you to have concern about how biased or unbiased these doctors are going to be. And not only that, but there is a big part, before we move on to the last point, there is a big part of the language in the new law about managed care that says that the insurance company not only gets to decide who these doctors are and, you know, what your treatment is, but gets to adjudicate.
Right, and that's what I wanted to,
that's
what I wanted
scary.
to point out. Thank you.
What does that mean in plain language? What does it mean if you buy the cheaper managed care option? You're in essence letting your insurance company adjudicate your treatment. What does that mean?
That's a great question. So it actually says even more than that. It actually says they're allowed to monitor and adjudicate,
yes,
meaning they get to know everything that's going on about your treatment. And then adjudicate means to make decisions about, right? So that means they get to make decisions about your care. And I'll be frank, if I have an insurance company who's supposed to be providing coverage to me when I'm injured, I don't want the insurance company able to decide definitively.
Because they may decide to save money.
Yeah, right. I don't want them deciding things about my treatment. And the fact that the statute actually says the policy may include the monitoring and adjudication of the injured person's care. I mean, that language to me, as a kind of a pro-rights guy, I mean, I'm always looking at, what are our constitutional rights, what are our statutory rights? That, to me, is giving up an awful lot of your rights. If they, the insurance company...
and let's be clear, insurance companies are not even doctors. They are adjusters. No. And they are being asked under the law, if you buy managed care, to make medical decisions for you about whether you should treat, not treat, stop treating, do surgery, not do surgery, do more physical therapy.
Yeah, at least that's how it reads. Now,
that's how it reads.
So
And that's all we can go by right now until somebody files a motion and motions get filed and judges hear them. And I mean, I don't know how the judges are going to rule. There is no legislative intent other than a broad legislative intent to save money.
Right. So, and that's the trick. So that's exactly right. And I'm glad you brought that up, because that's exactly what I was going to go to. Is I think the adjudication language, even more than the network, is a little scary, because I don't think my HMO has the right to adjudicate whether or not my treatment is reasonable and necessary.
No,
so.
The HMO, all it says is, here is our list network of doctors, you choose one. But your HMO adjuster does not sit and make decisions as to what your HMO doctor is doing and whether you need to be seen again and whether you need an injection and whether you need a medication or not. They don't sit as doctors making medical decisions.
Yeah. So and that's exactly right. So I think that you really waive a lot of rights right now as it reads with the managed care option. So
Rami, we did talk about that managed care option before, and we did say that, it's a very, very bad idea. I really hope that the information, we talked about it a different way today, and we had Attorney John Schroeder. I hope that the information that we shared is strong enough to discourage listeners who want to save money from going into the managed care option. It's a very, very, very bad idea. Not only do we not know what it is, but just having your own insurance company decide your doctors, and having your own insurance company adjudicate, meaning making decisions. So the insurance company is going to tell those doctors, stop treating, don't give him treatment, don't give him surgery, don't do this, don't do that. That's very scary, because what are insurance companies, Rami, in the business of? Making money, not spending money. Insurance companies don't want. That's why some insurance companies will not even take people when they become a big risk, because they don't want to spend money on people. They'd rather cut somebody's policy and have them go somewhere else than keep people, whether it is health insurance, whether it's car insurance, when they find that this person is a lot of risk. Why? Because insurance companies are in the business of making money, not spending money. In the 6 minutes remaining, Attorney John Schroeder, we did not talk about Uber and Lyft. Now, Uber and Lyft, effective June 11, and that's not for the person who's driving for Uber or driving for Lyft, but it's the insurance companies for Uber and Lyft. They now have to raise their policies to $250,000, effective June 11, correct?
There are going to be new limits. $250,000 is a...
We're losing you a little bit, John. You may want to get closer to your microphone. I know you're calling from the office. Yes.
Yeah, my apologies. Yes, there are new limits coming into effect. There are some interesting sort of changes that are going into vehicles that are in the business of transporting passengers.
Now, Attorney John Schroeder, that does not affect this change in the law that took effect on June 11. That affects insurance policies from Uber, from the Uber company.
Yes.
Not the person who is using his car to drive for Uber or Lyft, correct?
Yes. Generally speaking, that it changes the effective coverages for Uber and Lyft and what they have to provide. Yes.
Okay.
However, there are provisions that change how uninsured motorists who might be in a vehicle, how their coverage may change as well now.
Okay. We're not going to talk about it because we only have 3 minutes. Can you take this time to impress upon the listeners who drive for Uber or Lyft? What do they need to do with their own personal car insurance? I have a car. I'm insured to AAA. I'm driving for Uber. I'm driving for Lyft, or I'm driving for both. What do I have to do? What do I have to tell AAA?
Yeah. So, you know what? Almost all insurance company policies include a provision that requests information about your employment status as well as the regular use of your vehicle. So what does that mean? That means they want to know who you're employed with and how you use your vehicle. And you might ask, well, why is that relevant? Why is that important? Well, if you potentially are employed in a position where you are sitting sedentary at a desk and there's no risk of you being hit on the 10th floor of an office building, that may be a different risk than you being in a car all day. For example, driving for Uber and Lyft.
Although if you open the Uber or Lyft application, or if you have a transportation, this is all the responsibility of Uber. But why would AAA, for example, care? Because that makes you a tired driver, even when you turn your Uber application.
Yes,
because you've already drove 4 hours for Uber or Lyft. So AAA wants to know that, you know, in those other hours, you're driving, and that makes you a higher risk for a car accident, even on your own personal time.
That's exactly right. You generally speaking, what the insurance companies would argue is that you're at higher risk. You're going to be driving in more populated areas that are more dense, and you got to drive out of them at some point, or through them. If you got there, if you got there, you got to get out of there, even if you don't live in that area.
Have you seen policies that were claims that have been rejected in our office because the person who came to us is driving, even if the accident did not happen while the Uber application is open, but on his own personal time? Have you seen a person's personal car insurance deny a claim because that person did not notify their own personal insurance that they are on occasion drivers for Uber or Lyft?
Yeah, in fact, some insurance companies are not going further than just saying you have to notify us of employment or general driving status. They actually have a specific provision in there saying that, and I believe AAA is one, although I would have to double check because I review a lot of different insurance policies, but they have specific provisions in there that are saying you must notify us if you use a ride-sharing company, and they even will say, such as Uber or Lyft, right in there. So, what they're doing is they're putting a contractual duty on the individuals who start driving for Uber or Lyft to notify them so that they can decide whether or not they want to continue to afford coverage or change the premiums or anything else. And, in fact, I just had a case very recently where I had an affidavit that was provided to me from the adjuster right away at the beginning of the case saying, we would never have even written this policy. Wouldn't have done it. Wouldn't have insured them at all.
They would have turned down that person. Yeah.
Yeah. If we had known that they were driving for Uber and Lyft, not even would we have had a higher premium. We wouldn't have written it in the first place.
So in other words, we have had cases being turned down, claims being denied because the person who came to us with an accident on his own personal time failed to notify Uber or failed to notify their own personal insurance company of the fact that they occasionally drive for Uber or Lyft.
That's exactly right.
And an affidavit from an adjuster that says, had I known, I wouldn't have even offered coverage.
Yeah, and what they do is they get it from their underwriting department. So the people who actually develop and calculate all the numbers for this. They do.
I would love to have
numbers.
The time is up. I would love to have a copy of that affidavit and read it on the air. Thank you, Attorney John Schroeder. You offered a lot of valuable information today. Thank you to all the listeners, and Rami, thank you to you. And tomorrow, God willing, with Attorney Katie Plade, talking about criminal law and family law.
شكرا
Thank
لكم.
you very much for having me.
Thank you. شكرا لكم مستمعينا على حسن المتابعة، ودمتم في رعاية الله. إلى اللقاء.